The President, please be seated. The chamber is now back in session. The chamber would like now to give the floor to the international co-prosecutor to make their presentation.
Monsieur le Président,
Mr. President, honorable judges, good morning. May I inform you that I'll use all the time allotted to us, about 36 minutes. Since your decision E-187 on case number 1 on the same subject, the situation has changed. The research during the period from 1975 to 1993 has changed. New arguments have been raised, and on the 11th of January last year, the pretrial chamber took a decision which is in line with the position adopted by the 3 national judges of that chamber a year ago. Another fact would justify a review of the situation by your chamber. That is the timing of its considerations. Your decision of the 26th of July 2010 was taken on the same day Kaingek Yav alias Duke was convicted. In the separate decision of the chamber, I quote, "Due to the substantial overlap between the elements of these domestic crimes and their international corollaries, this finding has had no impact on the Chamber's evaluation of the totality of the accused's criminal culpability or on the sentence ultimately imposed." End of quote. Let me point out in passing to clarify this sentence, which prompted the co-prosecutors not to lodge an appeal against the decision. The most important point is to look at the judgment. It is not that we acquiesced in your decision with regard to your decision on national crimes. The situation and the timing is different here. In directive in your directive of the 5th of April 2011, you ruled on the issue and on the merits. The situation is not the same. The stakes are different today, since the chamber has to rule without having looked at the evidence in the case. It is important to note that the elements of international crimes are satisfied. In fact, the elements of these national crimes, that is homicide, torture, and religious persecution, cannot be likened to those of international crimes, even though they are similar to a large extent. We are of the view that the facts and the law in our written submissions are today sufficiently supported with regard to the lack of the elements or the lack of statutory limitations for domestic crimes for the period from 1992 to 1993. We'd like to point out that the statutory limitations period did not start running before that period, and once they started running, they were extended by 20 years pursuant to the ECC law and the amendment to the law in 2004 regarding the hypothesis that the prescription period would have expired before the adoption of the 2001 law. I would like to refer you to the decrees we sent to you previously. Before looking at the substantive issue, I would like to address 2 points of law that the defense referred to a while ago, to say that Article 3 or 3 new hasn't violated the principle of legality, and secondly, that the same article did not violate the principle of equality before the law regarding the principle of non-retroactivity. The situation is very clear. Insofar as there is no statute of limitations, it is subject to all laws that amended the time frame. In other words, when the 10-year time limit had not expired, the extension of the renewal of Article 3 of the ECC and Article 3 new of the 2004 law cannot violate the principle of non-retroactivity. As a matter of fact, the extension of the timeline did not occur, as the defense suggested, to aggravate the situation or to modify the definition of those crimes. Article 7 of the European Convention of Human Rights and 15 of the ICCPR are not applicable to these crimes. As a matter of fact, the crimes for which the accused are charged before this chamber are exactly the same as those for which they were punishable between 1975 and 1979. This fact is not contested. These national crimes existed not only in the 1956 Penal Code, but they were also considered as felonies according to the general principles of law recognized by all nations. The international judges of this chamber have confirmed that the statute of limitations could be extended before its expiry by an explicit law, and that this would be compatible with international fair trial norms applicable before the chamber. That is pursuant to Article 15 of the ICCPR, paragraphs 43 to 47 of your decision of July 2010. Furthermore, the statute of limitations does not affect the crime itself or the sentence. It is a manifest part of the procedural rules regarding the conduct of proceedings. It is therefore a procedural as opposed to a substantive rule. Regarding the principle of equality before the law, the extension of the statute of limitations does not create any inequality before the law, according to Article 26 of the ICCPR, because the principle of prolongation is in line with all norms of international law. In other words, the adoption of the ECC law and the prolongation of the time limit for the statutory limitations does not affect the situation of the accused. The principles are based on reasonable and objective grounds, and the accused can be prosecuted for the same crimes under the law, insofar as any individual fulfills the requirements of personal, temporal, subject matter jurisdiction. The suspects identified by the prosecutor can be charged, and it is therefore not a question of unfair treatment as the defense has claimed. Quite on the contrary, there is a fundamental principle that underpins international criminal law, and it is that those responsible for serious violations of human rights and war crimes must be brought to justice before the court. It doesn't matter whether according to the issue of personal jurisdiction or those responsible, or the fact that these people constitute a small number of people. It doesn't matter. Honorable judges would like to proceed by addressing the submissions of the defense in its joint response of the 17th of June, paragraph 10. The defense stated that the 1956 Penal Code remained in force between 1979 and 1991, and that it was not applied because it was not abrogated. The legislative decree of 15th of April 1980 of the Democratic Republic of Kampuchea focuses on crimes relating to the crime of treachery, rape, murder, and physical assault, and crimes against property. According to defense, this decree coexisted with the 1956 Penal Code. This interpretation is not reasonable, and we call on the Chamber to consider this legislative decree very attentively, and the reference is D288/6.9/9.4, and you would observe that there is no doubt as to the intentions of those who drafted that law. It is a revolutionary law that was adopted in an emergency situation, but it is a complete law which covers all aspects of the crimes and the aspects of criminal law. Most of these crimes are understood as treachery to the revolution. It indicates that the Revolutionary Council, which adopted the law, was fully aware of it. And you would also note that this law is retroactive according to Article 12, which applies to all the crimes, all of them, that were committed from the 7th of January 1979. There is no reference to other crimes contained in the 1956 Penal Code. As such, at least if the 1956 Penal Code had not been officially abrogated, we can assert unequivocally that it was certainly suspended after the 7th of January 1979, and the context also shows that with regard to this interpretation, there was change of power after the revolution, a change of constitution, and adoption of certain laws that broke with the situation of the Khmer Rouge regime. So these decrees were imperfect. I would like you to look at Article 92 of the June 1981 Constitution that asserts that all the legislative decrees and decisions of the Revolutionary People's Council lend credibility and force of law to this law. The consequences of the observation that the 1956 Code was suspended or abrogated throughout the period from 1979 to 1991 are essential. Neither in the legislative decree or the 1982 decree regarding the organization of courts and prosecutions, reference is E51/7/3.1.1, and it is available in Khmer. Neither the decrees regarding the establishment of the People's Supreme Court in 1985-1987 would you find any procedural provisions regarding any statute of limitations. To our knowledge, there is no statute of limitations applicable between the 7th of January 1979 and the time when the provisions of the 10th September 1992 Code regarding the judicial system, criminal law, and criminal procedure applicable in Cambodia during the transitional period prepared with the assistance of UNTAC. Article 30 of these provisions of the UNTAC Code establishes or restores the deadline for application of statute of limitations, which is 3 and 10 years. This is the reality. Nothing, therefore, justifies that the authorities in charge of prosecutions or the revolutionary courts during the period of Democratic Kampuchea carried out investigations or prosecuted people during the period of the Khmer Rouge, because these time frames did not exist. As the defense claimed, the expiry on the 6th of January 1989 of the statute of limitation, as it's claimed, is not false. So we cannot impose that on the judges regarding to the situation from 1979 to 1992, whereas the decrees and applicable laws were not time barred. The very first possible date for the statute of limitations with regard to national crimes coming into effect is that of Article 30 of the UNTAC Code of September 1992. And if I am not wrong, it went into effect 2 months after it was adopted. And this brings us to November 1992. Since the time limit for the statute of limitations hadn't started running and therefore could not have expired, according to Article 3 of the ECCC law, which increased the time frame to 30 years for national crimes, Article 3 of the ECCC law did not violate the principle of legality and therefore has no incidence on the situation of the accused who are being charged of national crimes. In the second part, and this is in the alternative, if the chamber is not satisfied that no time limit or statute of limitations was applicable between 1979 and 1992, would therefore invite the chamber to look at a series of principles of law and factual circumstances that are likely to lead you to a finding that the statute of limitations did not start to run at least up to 1993, and this for reasons that have been presented by my colleague. First of all, there was no functional court, and secondly, there was a situation of war, and thirdly, the war was waged by the accused themselves. The principles of law and criteria applicable have been determined essentially by Western law. Western countries have never witnessed the exceptional situation as that which obtained in Cambodia after January 1979 because of the situation of war. Cambodia was a country in ashes. It had been bled dry and ravaged by war and the decay regime. Most intellectuals had been either massacred or had died in enslavement. They were in refugee camps, and a quarter of the population had been amputated. The priority of the new leaders appears to have been to stabilize power and to reconstruct the country, and not to devote themselves to justice. As Westerners, we should be humble enough to consider this situation as it was and consider the facts and the law. The only example is that of a judicial system which is completely destroyed. And I would like to talk of the doctrine of inability to act. Contra non valentem agere nulla curit prescriptio, which means prescription doesn't run against whoever is unable to act. Without naming it explicitly, it is pursuant to this principle that all the judges of the pre-trial chamber and your chamber held that any investigations or prosecutions during the DK regime was rendered impossible in the absence of a functional judicial system, and this transpires from paragraphs 14, 17, and 29 of your decision, and paragraph 285 of the decision of April issued by the pre-trial chamber. In the same paragraph, the pre-trial chamber also pointed out rightly that if the goal of the statute of limitations is to provide a time frame during which criminal prosecution can occur. This would presuppose that the judicial institutions function effectively. Insofar as the judicial system and institutions that made it up function effectively as from January the 7th, 1979, is that the case? It is not a question of mixing up a functional, operational judicial system or a system that is ideal or perfect. And these are the words that the defense put in our mouths in their joint reply to paragraph 5. Our position is that a judicial system that is put in place should satisfy a number of minimum criteria for it to be considered functional. These criteria, according to us, should be appreciated in concrete terms and not solely on the basis of the legislative arsenal that existed at the time. It is important that the court should be able to address the issues in the case file, to gather evidence, to hear prosecution and defense witnesses who testify without fear of reprisals. A tribunal that functions implies not acting arbitrarily or acting with bias. Without these guarantees, we cannot talk of a functional court, pursuant to the principle contra non valentem. The system put in place by the DK, or the People's Republic of Kampuchea, which persisted with some fundamental reforms from 1992 to 1993, is not only a system which was not functional, but it did not provide any minimum guarantees for it to be considered functional. We cannot, it reminds us of the mock trial of Pol Pot and Ieng Sary in 1979, on which the parties made submissions on Monday. The Chamber will also observe that in the documents provided, the corpus of international legal norms was incomplete at the time. It is important to compare the Constitution and the laws in force with those adopted in 1992. My colleague said, and I will sum up, that before the reforms of 1992 and 1993, the judicial system and the courts provide no guarantees neither for the defense or for the victims.
De qualification.
There were no courts of appeals. They were deemed unnecessary. Judgments were reviewed by the Ministry of Justice. And arrests were made without any credible judicial basis. Evidence was not collected, neither before nor after arrest, with the exception of only a few. This is the harsh reality. These are the objective facts that many authors and analysts have described in the publications that we have attached and referenced in our submissions. In such a system, it's not a matter of knowing whether a particular tribunal or a people's tribunal would have individually been able to conduct investigations or suspend a statute of limitations, but consider the system in its entirety, as well as its components, and to ask the question as to whether or not the minimal conditions and guarantees for a proper functioning judicial system were truly met. The defense teams have shown their capability by pointing out that certain Cambodian judges of the ECCC had occupied official judicial functions during the 1980s. In fact, the co-prosecutors agree by saying that it is precisely the Cambodian judges who are in the best position to assess the judicial system that prevailed in Cambodia between 1979 and 1993, especially since they experienced in successive order the state of justice under the regime of the People's Republic of Kampuchea, the judicial system under the Kingdom of Cambodia that was established with the assistance of UNTAC. And in light of this fact, we believe that all Cambodian judges who have made a finding on this issue as to whether or not there was in existence a functional judicial system between 1979 and 1993, they did so each time with courage, and they did so each time with objectivity. The defense also submits that the Constitution of the People's Republic of Kampuchea in 1979, or rather, the Constitution of June 1981, proves the existence of a functional judicial system. Now, with respect to the 1981 Constitution, we invite the Chamber to compare this version of the Constitution with the 1993 Constitution, and we make the two following points. Firstly, the preamble of the 1981 Constitution contains the sentence, or rather makes reference to the Pol Pot Ieng Sari Keo Sampan clique, who had become lackeys of the expansionist and hegemonist leaders of Peking. This is not the language of a classic constitution, and it only gives an idea of the nature of the judicial system established during that period. This also reminds us of the observations that have been made about the Pol Pot Ieng Sari trial that was held in 1979. It was rather a political trial held to reaffirm the power in place amidst war, and which is bereft of any will to establish functional justice. The second point is this. Where the 1993 Constitution establishes a clear separation of powers, an independent judicial power under the authority of a Supreme Court and the Supreme Council, it does not invest this power in professional judges to adjudicate. This is in contrast to the 1981 Constitution, and in fact, Articles 79 to 86 are very vague and are silent on the separation of powers, on the hierarchy of courts, and does not reference the existence of the People's Tribunals or military tribunals in Article 80. It simply mentions the presence of those who assisted the judges and does not make any reference to defense rights. In fact, the very few guarantees that are set out in this Constitution refer to administrative matters which are simply not substantiated in fact. As you have said, a period of war can toll or postpone the start of a statute of limitations. Several national and international practices establish that the state of guerre may interrupt the functioning of a judicial system, which necessarily engenders the suspension of the statute of limitations. At the national level, this has been the case for Germany between 1933 and 1945, and there are judicial decisions in this respect that emanate from the United States, France, and elsewhere in Europe. At the international level, there is the principle of the suspension of the statute of limitations for citizens who are nationals of two powers or in war. Cambodia enters this scenario. However, in reality, as of 1998, the name had simply changed. It was not a war between two powers. Otherwise, the United Nations would not have considered as legitimate leaders of democratic Kampuchea and denounced Vietnam as the occupying power. In addition to a judicial apparatus that was not functional, any investigation or prosecution would have been manifestly obstructed by war and by partial occupation of Cambodia. There was absolute impossibility to arrest the accused or even to summon them as witnesses. The priority was to wage war. This is certain. As my colleague has already stated to you, aside the absence of functioning tribunals in a situation of war, there is also a third legal ground that justifies the postponement of the start of a statute of limitations. It is the principle that is summarized by the legal maxim that no one is heard when alleging their own fault. Because of this principle, the statute of limitations cannot be invoked by the accused. The pretrial chamber has already emphasized this in paragraph 286. It has been alleged that the accused are partially responsible for the fact that the judicial system at the time was unable to carry out investigations and prosecutions during the period of January 1979 to September 1993. We believe that they had destroyed the judicial system as well as all of its components between 1975 and 1979, and this, as a consequence, had a heavy incidence and impact on the entire system of Cambodia during the 10 years following the fact, and perhaps even to this day. Secondly, the accused persons are also partially responsible for the war that had obstructed prosecution from 1979 up until their surrender. For the co-prosecutors, it is unacceptable that by reasons for which they themselves are responsible, that is, they had obstructed prosecution, that they should be able to reap benefit from this. And what benefit this is, that is impunity of national crimes. Mr. President, your honorable judges, this brings me to my conclusion. I ask you to declare yourselves as having jurisdiction over the charges that have been made against the accused, charges stemming from national crimes of homicide, torture, and religious persecution, because there was no statute of limitations between 1979 and 1992. And I remind you that this is a matter of procedure, and in the alternative, I also ask you to find that under all objective criteria, the Cambodian judicial system was incapable of conducting investigations and launching prosecutions during the period that followed the fall of democratic Kampuchea up until, at the very least, 1993. Subsequently, the 2001 Establishment Law under Provision 3 extends the statute of limitations. On that, I end, Mr. President, your honorable judges, and I thank you.
The President, thank you, Mr. Co-Prosecutor. Next, we proceed to the civil party legal lawyers. For the response to the observation by the defense counsel. Counsel Pek Ong, Mr. President, Your Honors, the civil party co-lawyers would like to divide the time allocated by the chamber to Mr. Lau Chun Thi, Mr. Kim Meng Ki, and Mrs. Chet Van Lee, and I myself, Pek Ong, to make the response. The President, the chamber have taken your note, and now it is floor for the counsel for the civil party, Mr. Lau Chun Thi. Counsel Lau Chun Thi, Good morning, Mr. President. Good morning, Your Honors. I am representing the civil parties, and I will be here addressing the topic of preliminary objections as indicated by the Chamber. I would be touching upon the context of Cambodia and the situation after 1979, of course, in the aftermath of the collapse of the Democratic Cambodia, and in what context was Cambodia in. And I will also be presenting the observation concerning how Cambodian people were returning to their villages or to other locations after they had been evacuated during the regime. When people returned home after the ordeal, there was huge shortcoming, and there was a government at that time established under the People's Republic of Cambodia. That government was started, and that the human resources were also reinstalled, and everything started from scratch at that time. Even the general administration system was reinstalled from the very beginning. We then proceed to the new period, the period in which several laws were adopted. In the state of Cambodia of 1989, when the state of Cambodia was created, the country was governed by the socialism ideology, and that the country's infrastructures did not prosper significantly. And now it leads to the question how such a statute of limitation could be applied. In 1991 to 1993, it is a new turn. Cambodia came to a new turn as a new constitution proclaimed the country state of Cambodia. And at that time, Cambodia was campaigning for true peace for the people of Cambodia who were hungry for it. And the election was in place. After the general elections, the question remains whether such a statute of limitation could be applied. The answer is that the civil war was still in place. And the question is, what was the civil war for, and between whom the civil war was staged against, for example. And we also know that the Khmer Rouge at that time boycotted the general election. After the election, the civil war was staged. And because of the civil war, the judicial function was not properly in place because it was hampered by this war phenomenon. I would like now be talking about the implication, the consequence of the Democratic Cambodia and the impact on the Cambodian society as a whole. Human resources have been or had been fully or significantly destroyed. The government had to restore human resources. And when I am talking about human resources, we refer to how people were sent to get better education in other countries, socialist countries like in Russia, in Vietnam. After resources or human resources have already been trained and gathered, it was possible for the government to proceed with other important tasks. For example, creating a judicial justice system for Cambodian people and for those whose loved one perished during the Khmer Rouge regime, and that the ECCC was eventually established. The Khmer Rouge regime destroyed all kinds of infrastructures, including the human resources. According to this submission, we find that the statute of limitation as presented by the Defense Council shall not be applied during that time because there were shortcoming of resources, and the judicial system was not properly functional, and such a court system remained dysfunctional until 1993 when the election was conducted or organized, and even early years after that election, we still experienced a civil war, and that the judicial system was not really in proper function only until 1998, and that concludes my submission.
Mr. President, with the deepest respect for my colleagues, I don't wish to interrupt. However, what we're hearing is more of a testimonial in something similar to either an opening or testifying from counsel. And I understand that there is a certain need to bring out some facts as part of a narrative. But here we are dealing with issues of law and not testimonials as to how the system or how Cambodia was. Now is the time to present, if they have evidence, they could have done that in their motions. But I think that we need to keep the discussion on the level of law and not the experiences of the individuals that lived throughout this period. And so I would be asking the trial chamber to caution everyone, including the defense, to stick to the law. Thank you.
Okay, so the
President, we would like now to proceed to the next counsel for civil party, the lawyer who already accredited for representing the civil parties, and we will end with the counsel before lunch break. Counsel Kim Ming Ki, Mr. President, Your Honors. I also thank you for the observation of the Defense Counsel for Ieng Sary. As in my capacity as the counsel for the civil party, these preliminary objections could never be made without any reference to the facts at issue so that the parties to the proceeding can be well informed of them. The co-lawyer for the civil party would like to respond with regard to the preliminary objection concerning the domestic offenses within or under the 1956 Penal Code. First of all, the civil party co-lawyer are convinced that the 1956 Penal Code exists and applicable during 1975 through 1979. And this statute of limitation is still valid before the ECC as already stipulated under Article 3 of the ECC law. And the ECCC has a reasonable ground for extending this statute of limitation as indicated in its law. From 1975 to 1979, roughly 3 million people, including judges, prosecutors, lawyers, intellectuals, and other people who had been killed or executed. And during that regime, people who could escape such ordeal, including children, have seen their rights deprived of, and they had to live in the condition of the prison without wall. In the decision, in the order by the co-investigating judges, finding is that crimes against humanity of genocide, for example, or homicide and religious persecution in 1956 Penal Code are applicable before this tribunal. I would like to also submit that the statute of limitation that is suspended or extended by Article 3 is the procedural law, not substantive one. And I believe that this extension of the statute of limitation does not violate the non-retroactivity of criminal law under Constitution. Even the Constitutional Council already stated that the statute of limitation extended under Article 3 of the ECCC law does not violate the Constitution. The extension of statute of limitations also guarantees the equality of arms and principle of justice for everyone. The suspension and of statute of limitations from 1975 to 1993 was done, and it was not only aimed to focus on the senior leaders of the Khmer Rouge leader, but such suspension was also done for the purpose of seeking justice for the victims of the Khmer Rouge regime, so that there are proper procedures in place to bring about the national reconciliation between the victims and the low-level former Khmer Rouge soldiers. According to a survey conducted by the University of California, Berkeley, the survey finds that the most priority is not justice, but economy and health issue. I draw your attention to this particular survey is to just reflect that victims have been very concerned with their economy and also their health condition, and that although they would like justice to be done to them, but for the period from 1979 to 1993, it was impossible for them to ask for justice to be done because they were so hungry and they were reduced to be thinking only of their stomach. On top of that, during the Khmer Rouge, during the state of Cambodia, the Khmer Rouge still occupied large parts of Cambodia territory, and they were also member of the Supreme National Council. And for that reason, there was no prosecution against them. That's why the statute of limitations extended to cover the crimes of those who committed crimes during the Democratic Cambodia is intended to secure the right to justice and to the truth. The co-lawyer for the civil party would like to also reaffirm our position to support the facts and law as reiterated by the prosecutors and the national judges in case file 001, that the statute of limitation was interrupted during the period where there was no proper functioning of the court system, and that no court would be able to prosecute the accused persons. National judges in case file 001 indicated that there was until to date no parallel measures being in place to secure the prosecution of the accused persons because the statute of limitations were interrupted. This idea was also actually supported by the Defense Council. The Council for the Civil Party note that the victims have the rights to reparations, remedy that they have suffered from the destruction and the suffering they endured during the Democratic Cambodia. The spirit of the establishment of the Penal Code of 1956 is to prevent crimes from happening and also to punish people who commit crimes and also to seek justice for the victims. In the case of Alfredo Corti, the court, the American court, ruled that even though the statute of limitations runs out, the justifiable suspension or extension of statute of limitation is warranted because the regime of Argentina, the authoritarian regime of Argentina, could not restore the judicial system to bring justice for the victim. And in 1979 to 1989, Cambodia was a socialist country ruled by the People's Republic of Cambodia. Under socialism, there was a notion that the state controlled the party governance. So all properties, belongings belong to the state, and it is the party who governs the country. Even there was a court at that time, any decision of the court would not be subject to any judicial review because the party fully controlled the country. During the negotiation, the Paris Peace Accord agreement, it is also another reason that tell us about how the judicial system back then was not really properly functional. In reality, the trials of Ieng Sary and Pol Pot in 1979 by the People Revolutionary Tribunals, the rights of the victims and the accused themselves were not guaranteed because the trials was not conducted properly. The equality of arms was not really preserved. And justice was not done for the victims in particular. As I already indicated, the civil party lawyer see that the judicial system of Cambodia was not properly in place to allow prosecutors or investigators to conduct proper investigation or prosecutions of crimes. Between 1979 to 1993. As indicated in the decision on the appeal by defense for Ieng Sary against the closing order, the suspension of a statute of limitation during the time when the judicial system was not functional was also appropriate because it is really justifiable to make sure that the victims can seek reparations and remedy for the crimes, for the damages caused to them during the regime. From 1975 to 1993, no Cambodian law or no circumstance allowed civil parties who were victims or relatives of the victim seek reparation or collective reparations as indicated here in under this ECC law and the internal rules. The suspension of statute of limitations from 1975 to 1993 was intended to ensure reparations for the victims, and it is pursuant to the 1956 Penal Code and also pursuant to the ECCC law. The civil party co-lawyer also supports the decision by the pretrial chamber that the statute of limitations with regard to national crimes start to run from the 24th of January 1993, the date when the Constitution was promulgated, and the date when the powers of the executive, legislative, and judiciary bodies were separated. Article 3 new of the ECCC law was enacted with regard to the extension of statute of limitations to cover the prosecution of national crimes. The evolution of victims' rights can be seen in Barrio Ato's case versus Peru. the Inter-American Court ruled that the court would not really accept any pardon of amnesty or any matter of statute limitations that bar the court from prosecuting people who commit heinous crimes. So we can also conclude that the extension of statute of limitation is applicable before chamber because it is done for the purpose of finding justice for everyone concerned. Statute of limitations as extended under ECCC law is a special statute of limitations. This court is a special court created by a special law. That's why ECCC is not bound to interpret the matter of statute of limitations bound by national law. ECCC has power to prosecute anyone who committed crimes under 1956 Penal Code and the crimes committed between 1975, the 17th of April, through the 6th of January 1979, including homicide, torture, and religious persecution. According to these arguments, the statute of limitation is extended to be consistent with the rights of the parties concerned. And the extension of statute of limitation rule is the special rule that overrides other provisions, relevant provisions. In the decision of the pretrial chamber on the appeal by defense team of Ieng Sary against the closing order also indicates the issue concerning the statute of limitation and that it is reasonably or justifiably extended before the chamber with respect to the individuals and the time. And recently, the civil party lawyers support and are grateful to the pretrial chamber for making a final decision concerning the acceptance of a few more hundreds of civil parties in their decision. And I would like to quote paragraph 35 of that order as follows. According to Rule 21 of the internal rule, the pretrial chamber is obliged to ensure that the proceedings before the ECCC are fair. And everyone shall be treated equally the same. And the fundamental principle of the ECCC, as stipulated under Rule 21 of the internal rule, requires that law shall be interpreted for the purpose of protecting the rights of all parties concerned. The co-lawyer for the civil parties is fully aware that any interpretation or the interpretation by the pretrial chamber does not bind the trial chamber. However, the co-lawyer for the civil party hopes that the trial chamber will also interpret the fundamental rule concerning the statute of limitation and its extension for the purpose of preserving the rights of the parties and also to maintain the equal rights of the parties. As mentioned above, the civil party co-lawyer would request that the trial chamber the suspension or extension of statute of limitations is reasonable and applicable to ensure fairness and to ensure that national reconciliation is carried out properly and to make sure that victims receive proper reparation. Finally, on behalf of the civil party and as victims of the Democratic Cambodia, civil party co-lawyer would like to request respectfully that the trial chamber set aside all the arguments and observations made by the defense counsel with regard to the preliminary objections concerning the statute of limitations under 1956 Cambodian Penal Code. The President, thank you, Council. It is now an appropriate time for an adjournment. The Chamber will take the adjournment from now until 1:30. Parties are also now advised to come back to the courtroom by 1:30. Security personnel are now instructed to bring the accused person, Mr. Khieu Sampon and Mrs. Ieng Thirit, to the holding cell and return them to the courtroom by 1:30.
សូមអញ្ជើញគ្រប់ឈរ